She dragged me to court over land that's been in my family for generations. What she didn't know is I wrote the kind of laws she thought she could twist. The land was more than just soil, trees, and fences. It was legacy. It had been in the family for over 70 years. Purchased by a grandfather who worked 2 jobs to afford even a small corner of peace outside city limits. Over the decades, it evolved into a fully functioning ranch, a mix of grazing pastures, wooded boundaries, and a modest but well-built home. Every inch of the property had a story. Every fence post, gate, and trail had been planned, walked, ridden over by generations. For years, the ranch remained undisturbed. It was outside of city zoning restrictions and existed far from the nearest town's regulations. There was no HOA, no communal oversight, just privately owned land with clearly documented boundaries. Property lines registered with the county and surveys confirmed and filed. The ranch's access was private as well. Single dirt road led from the main highway to the entrance, and that road, too, was part of the deed. It wasn't shared. It wasn't public. It had always been privately maintained and gated. Things started to shift when a housing development sprang up a mile away. Developers had bought up adjacent acreage and carved it into uniform lots, advertising a modern countryside lifestyle for suburban families looking to escape the city. Part of their sales pitch included access to scenic surroundings and borderline rural charm. What they failed to mention was that the surrounding lands were privately owned and had nothing to do with the development's boundaries. But that didn't stop residents from exploring. One of the new homeowners, a woman named Karen, quickly positioned herself as the voice of the new neighborhood. She helped form an HOA within months and was elected president during its very first meeting. She was aggressive, organized, and deeply entitled. Her approach to leadership included monitoring other people's properties with binoculars, sending violation letters for imaginary infractions, and inserting herself into anything she believed involved community interests. Karen began to take a particular interest in the ranch. The long driveway, which curved past some scenic brush and led up to the gated entrance, became her favorite walking path, despite being clearly marked as private. When confronted, she claimed she was just admiring the land and argued that nature doesn't belong to anyone. That was the first red flag. The second came when she began sending emails through the HOA mailing list, describing the ranch as a community access point for scenic views and suggesting that the private road should be opened for shared, recreational use. Those emails didn't go unanswered. Multiple warnings were issued to her in writing, and a copy of the original land survey and deed was forwarded to the HOA board. It was made clear, politely but firmly, that the ranch and the road leading to it were private property, not governed by the HOA, and not subject to community access. Karen replied with condescension, stating that, as an HOA president, she had a duty to enforce fair use and clarify unclear land rights. The land rights were anything but unclear. The deed explicitly marked the property lines, right-of-way access, and all legal usage rights. Every square inch was private. Yet, Karen persisted. She printed out satellite images and drew her own property lines, arguing that historical paths and aerial maps supported her theory that the road was once used by locals and therefore qualified as an easement. Her argument lacked any legal basis, but that didn't stop her from acting on it. Soon, strangers began appearing near the property's edge. Families with strollers, cyclists, and dog walkers started using the dirt road, clearly encouraged by Karen's propaganda. When turned away at the gate, they expressed confusion, saying they thought it was open to the public. Karen had effectively turned private land into a community attraction without permission, without facts, and without consequence. Not willing to tolerate this continued trespassing, proper gate was installed at the entrance, reinforced with a clear sign that read, "Private property, no trespassing, violators will be prosecuted." That was the turning point. Karen, furious at being blocked, acts at the ranch owner of blocking shared land access and isolating the neighborhood from nature. She claimed to represent multiple families and threatened legal action. Behind the scenes, Karen had begun drafting a complaint. She cited community obstruction, easement violation, and even claimed the gate was placed to intimidate local residents. She misquoted zoning laws, invented access rights, and ignored all previous documentation that disproved her claims. With the support of her HOA title and a small circle of equally entitled neighbors, she filed a formal lawsuit against the property owner. To anyone familiar with land law, it was a laughable attempt. But to the untrained eye, it looked official. Karen believed that the mere act of filing suit would scare the ranch owner into compliance, or at least a compromise. What she didn't know, what no one on the HOA board knew, was that the person they were suing had a law degree. It's over 30 years of legal practice and more experience in land disputes than most attorneys in the county. Now, the land wasn't just family property. It was protected, prepared, and about to become the stage for one of the most satisfying legal takedowns in HOA history. Karen's obsession with the ranch didn't die down after the gate was installed. If anything, it escalated. She took the new barrier as a personal insult and an attack on the authority she thought she had as HOA president. What began as passive-aggressive remarks at HOA meetings quickly transformed into an aggressive campaign to prove that the ranch owner had no right to deny what she called community access. Karen's logic was flawed from the beginning. She argued that because the neighborhood was built adjacent to open land, and the road was visible from some of the new properties, it must belong to the community, or at the very least, be subject to shared use under local easement law. She conveniently ignored the fact that private ownership was clearly marked. She made no effort to verify her assumptions with the county records office or the local zoning board. She simply believed that if she pushed hard enough, the ranch owner would back down. What Karen didn't count on was pushback that was both legally grounded and utterly immovable. When she sent her first formal letter on HOA letterhead, demanding that the gate be removed or access be granted to all residents, she received a certified response within 72 hours. It included a copy of the original land deed, plat maps, zoning documentation, and a cease and desist demand. It also made it crystal clear that any further attempt to access the private road without permission would be considered trespassing and treated. Accordingly, Karen wasn't intimidated. She doubled down. She started holding meetings in her backyard, rallying neighbors to her cause. She printed out flyers describing the ranch as a public trail that had been stolen by a greedy landowner, and falsely claimed that the property had once been listed on a public access map, which it never had. She cherry-picked legal terms she didn't understand, using buzzwords like implied easement and community interest in casual conversation, as if she were preparing to argue a Supreme Court case. With her rhetoric growing more extreme, Karen convinced a few of her more gullible neighbors to join her in compiling what she called evidence of community usage. She encouraged people to take photos near the gate, walk along the fence line, and document long-standing paths that were nothing more than wildlife trails. She even went so far as to suggest that previous trespassers had used the land without complaint, and that the sudden enforcement of property lines was a violation of unwritten agreements. None of this had any legal merit, but it didn't stop her from spreading it. Behind the scenes, Karen began reaching out to a local attorney. Unfortunately for her, the legal counsel she hired had no idea what kind of case he was walking into. Presented with cherry-picked documents and Karen's dramatic retelling of events, he agreed to represent her in filing a lawsuit. She instructed him to include claims of illegal obstruction, denial of communal access, and emotional distress caused by sudden and aggressive land control. The lawsuit was officially filed 2 weeks later. A process server arrived at the ranch and delivered a stack of papers. Karen's attempt at forcing compliance through legal intimidation. The complaint was bloated, filled with inaccuracies, and completely misrepresented the nature of the land. It referenced outdated satellite images and argued that the existence of a visible path was enough to imply a right-of-way. There were no actual legal precedents cited. It relied heavily on emotional language and personal interpretations of property law. Karen made the announcement at the next HOA meeting with pride. She declared that the neighborhood was taking a stand and that the landowner would soon have no choice but to negotiate. She treated the lawsuit as a victory before it even reached the courtroom. Her supporters applauded her leadership, convinced they were doing something noble. They saw the gate as a wall, Karen as the hero breaking it down. What none of them realized, what Karen herself didn't even consider, was that the landowner she was suing had more than just land. They had knowledge. They were a retired attorney, fully versed in property law, and intimately familiar with every argument Karen was trying to make. The lawsuit wasn't just a threat. It was an opportunity. Instead of reacting with fear, the ranch owner responded with calm precision. Every claim was dissected. Every accusation answered with hard evidence. Counterclaim was prepared. The case that Karen believed would force compliance was about to backfire in a way she couldn't imagine. Her baseless crusade to force her will onto private land was now leading her straight into a legal trap, one that would be closed by someone who had written, studied, and argued the very laws she misunderstood. Karen thought she was intimidating, a quiet rancher. What she didn't know was that she had declared war on someone who used to train lawyers how to win exactly this kind of fight. The courtroom was never meant to be a battleground for petty entitlement, but Karen had made it one. She entered the legal system thinking it would be an extension of her HOA authority, a place where her indignation would be validated and her assumptions would be reinforced by a judge who couldn't possibly disagree with someone so community-minded. But the law didn't work that way. Her lack of preparation would soon collide with someone who knew exactly how the system functioned. From the very start, the ranch owner, now a retired attorney, treated the case with the seriousness it deserved, not out of fear, but out of respect for the law and a desire to shut down Karen's fantasy once and for all. Every document Karen filed was dissected, annotated, and countered with precise legal language. Every baseless claim was matched with indisputable evidence. The response to her complaint wasn't emotional or defensive, it was surgical, strategic, and loaded with citations that left no room for ambiguity. The legal filings submitted in response dismantled Karen's case piece by piece. It began by asserting the ranch's status as a privately owned property with deeded boundaries, recorded easements, and no public access. It pointed out that the road in question was clearly marked as private on county maps and had never been zoned or recorded as anything remotely public. It included photographic proof, zoning ordinances, and a historical timeline of ownership dating back decades. Karen's attorney, realizing that the case was not as airtight as she had claimed, attempted to pivot. He introduced vague arguments about implied easements and public utility based on common use, but those arguments collapsed when the court was shown proof that any supposed use by the public had only begun after Karen's HOA flyers falsely described the land as open. Prior to that, the land had remained undisturbed for decades. There was no history of shared use, no maintenance by outside parties, and no indication that the land had ever been treated as communal. One of the strongest blows to Karen's position came in the form of a counterclaim filed by the ranch owner. It wasn't just a defense, it was a legal offense. The counterclaim alleged harassment, defamation, misuse of the court system, and trespass, complete with sworn statements from witnesses, photographs of trespassing incidents encouraged by Karen's messaging, and evidence of coordinated efforts to undermine the owner's property rights. The court took notice. In legal terms, the case began to unravel. Karen's original complaint was based on misinterpretation and emotional entitlement, not on legal precedent or fact. The ranch owner's counterclaim, on the other hand, structured with the precision of someone who had spent a lifetime studying land use, property law, and civil litigation. Every paragraph served a purpose. Every exhibit supported the argument. Every motion filed was a tactical step toward both victory and accountability. Karen, used to winning neighborhood arguments with volume and persistence, now found herself bound by rules she didn't understand. Her confidence began to falter. Her lawyer, who had once spoken with assurance, now hedged his language and looked for ways to negotiate. The court, seeing the disparity in legal competence, began leaning heavily toward the ranch owner's side. It was no longer a question of whether Karen would lose, it was how severely. Depositions were scheduled. Under oath, Karen had to explain her motivations, her interpretation of land ownership, and why she believed her personal beliefs overrode documented property rights. Her contradictions became evident. She claimed to be advocating for the community but admitted she had never contacted the county about easement rights before filing the lawsuit. She asserted long-standing use but had no dates, no credible witnesses, and no records. When confronted with cease and desist letters she had ignored, she stumbled through weak justifications. The judge grew visibly impatient with the circus-like nature of Karen's arguments. What was supposed to be a civil matter about land had turned into a bizarre power struggle driven by pride, misinformation, and ego. The court wasn't interested in emotional appeals, it was interested in law, and the law wasn't on Karen's side. Eventually, the motion for dismissal of Karen's original lawsuit was filed. The ranch owner requested the court not only throw out the baseless claims, but also impose sanctions for the misuse of the legal system. The request included legal fees, damages for defamation, and an injunction to prevent Karen from making further false claims about access to the property. The judge, having seen enough, moved the case toward resolution. Karen's lawsuit would not survive the next hearing, but more importantly, her reputation, once inflated by power within her small HOA, was now collapsing under the weight of her own arrogance. She had come into the courtroom expecting a win by default. What she encountered instead was the full force of legal expertise. Calmly and thoroughly applied by someone she had underestimated from the beginning, the courtroom showdown wasn't loud, it wasn't dramatic. It was quiet, calculated justice, the kind that doesn't need to shout to be heard. Karen had entered thinking she was the one with power. By the end, it was clear she had never had any at all. The legal process had been exhaustive, but the outcome was now inevitable. Every attempt by Karen to manipulate the situation had not only failed, had exposed her recklessness. She walked into court with the false confidence of someone who believed position mattered more than proof, but the courtroom had no tolerance for delusion. It only responded to evidence, experience, and the law. And when the moment of judgment arrived, it hit harder than Karen ever imagined. The judge delivered a decision that was both swift and detailed.
Wow.
Karen's lawsuit was officially dismissed with prejudice, a legal term meaning she was barred from filing the same claim again. Her arguments had no merit, her interpretation of property access was fundamentally flawed. Her actions had crossed into abuse of process. The dismissal was not just a rejection, it was a formal rebuke of everything she had tried to do. But that was only the beginning. In response to the ranch owner's counterclaim, the court ruled decisively in their favor. The evidence of harassment, trespassing, and public defamation was overwhelming. Karen's distribution of false information to neighbors, her incitement of community members to access private property, and her use of HOA authority to justify unlawful behavior all added up to a pattern of conduct the court couldn't ignore. The judge called it an egregious misuse of community leadership and a complete disregard for lawful property boundaries. Karen was ordered to pay full legal costs incurred by the ranch owner. Every hour of attorney consultation, every document filed in defense, and every motion submitted to correct her baseless claims would now come out of her own pocket. The total was staggering for someone used to wielding neighborhood power with little consequence. The reality of owing tens of thousands of dollars in legal fees hit like a freight train. Additionally, the court issued a permanent injunction against Karen. She was forbidden from entering the ranch property or encouraging others to do so. She was also barred from publicly referring to the property as shared, public, or community-owned. Any violation of this order would result in immediate legal penalties, including potential arrest. The same neighbors who once applauded her defiance now watched her authority dissolve under the weight of accountability. Karen's reaction to the ruling was a mixture of shock and disbelief. She had built her case on emotional entitlement and expected the court to affirm her version of reality. What she received instead was a formal declaration that her behavior had been not only wrong but legally punishable. Her status as HOA president no longer gave her power. If anything, it now served as a reminder of the responsibility she had abused. The fallout extended beyond the courtroom. Word of the judgment spread through the community quickly. HOA members began resigning. unwilling to be associated with someone who had dragged the entire organization into a personal vendetta. Residents who once supported Karen began reviewing their own HOA contracts, questioning whether they had blindly followed someone who never truly represented their interests. Her credibility was shattered. The ranch owner, while satisfied with the outcome, made no effort to boast or gloat. Their goal had never been revenge, was simply to protect what was rightfully theirs, stop the harassment that had spiraled out of control. The ruling restored their peace of mind and affirmed that the law was still a place where facts mattered. They had been underestimated from the beginning, seen only as a quiet landowner standing in the way of progress. But they had proven that silence doesn't equal weaknesses, especially when backed by decades of legal knowledge. Karen, once the self-proclaimed voice of the community, now avoided eye contact in public. The people she once rallied now whispered behind her back. Attempts to frame the situation as a misunderstanding fell flat in the face of the court's ruling. There was no sympathy left to offer her. She had turned a simple boundary dispute into a full-blown legal disaster and paid the price for every misguided decision along the way. The verdict served as a warning not just to Karen, but to anyone who believes that entitlement can override truth. Property rights, legal records, and decades of lawful ownership couldn't be undone by inflated ego or false authority. The courtroom had spoken, and its message was clear. No one is above the law, no matter how loudly they speak or how many followers they claim to have. By the end of the ordeal, the ranch gate remained exactly where it was, reinforced by more than just wood and metal. It now stood as a symbol of boundary, justice, and quiet strength. Karen's lawsuit, intended to force submission, had instead elevated a retired attorney into a symbol of calm, calculated victory. And the only thing more powerful than the verdict itself was the silence that followed it when Karen finally ran out of arguments, allies, and excuses. Karen's downfall didn't happen in one dramatic moment. It unraveled in quiet, deliberate steps, each one rooted in her failure to recognize the difference between authority and expertise. Her position as HOA president had given her the illusion of power, but it was shallow, based on self-importance, not actual understanding of the law. And when she challenged someone who lived and breathed that law for decades, the illusion was shattered. The truth was simple. She had picked a fight she couldn't win. She didn't even realize it until it was too late. For the ranch owner, this wasn't just about protecting land. It was about principle. It was about defending a legacy from a person who believed rules didn't apply if she felt strongly enough. It was about reminding everyone watching, neighbors, community members, and future Karens, that there's a line between entitlement and action, and when you cross that line without facts, consequences follow. Experience had made all the difference. The ranch owner didn't just respond to Karen's threats, they anticipated them. Every misstep Karen made was met with calm documentation. Every exaggerated claim was met with a legal reality, where Karen relied on opinions and misread Google searches. The ranch owner responded with precedent, evidence, and precision. It was never about emotion, it was always about facts. That's what made the difference. Karen had underestimated not just the ranch owner, but the system she thought she could manipulate. She assumed she could twist the law to serve her personal sense of fairness. But the law doesn't bend for entitlement. It holds its ground, and in this case, it held firm in favor of the one person who never needed to raise their voice to be heard. In the aftermath of the verdict, Karen's behavior became noticeably subdued. The same woman who once marched around the neighborhood claiming to speak for everyone now kept to herself. The HOA board, now embarrassed by the legal circus she had dragged them into, quietly began the process of electing new leadership. No one pushed back. The residents had seen enough. They didn't want another battle for community rights. They wanted peace, privacy, and distance from the spectacle. What had started as Karen's campaign for power turned into her public unmasking. And while the court order restrained her legally, the social consequences followed naturally. She was no longer respected. She was tolerated at best and avoided at worst. The silence that surrounded her now was not born of fear, it was born of clarity. People knew who she really was. The ranch, meanwhile, returned to its natural rhythm. The road remained private. The gates stood tall, and the owner, the retired attorney who had so calmly dismantled Karen's crusade, went back to enjoying the land in peace. But something had shifted. Community now understood not just who the owner was, but what they stood for. They weren't just a quiet neighbor. They were a reminder that knowledge, patience, and restraint are powerful weapons in the face of chaos. Karen had believed she could rewrite the rules. She thought the strength of her personality would overpower the details of a deed. God experience taught her the most painful lesson of all. Feelings don't beat facts, and volume doesn't override the truth. The ranch wasn't just protected by fences or court orders. It was protected by someone who had spent a lifetime learning how to uphold the law, and who had no intention of letting that knowledge go to waste. In the end, the story wasn't about a petty lawsuit or a neighborhood feud. It was about boundaries, legal, personal, and ethical. Karen violated all three. The ranch owner defended all three. And that's what made the outcome so powerful. Because when entitlement meets experience, there's only ever one winner.